Hello. The topic of this video is equal protection analysis by the Supreme Court, and I want to talk just a little bit about how the court evaluates discrimination cases. As you know, equal protection is the clause in the 14th Amendment, which basically guarantees that all people in the United States should be treated equally under the law. Now, the meaning of that has evolved over time. When the 14th Amendment was first ratified in 1868, the idea behind it was that it would protect the citizenship rights of the freed slaves, because as you know, the slaves were set free by the 13th Amendment in 1865, but southern states continued to deprive the freed slaves of any basic human rights. So in 1868, the 14th Amendment was adopted, and that basically said that all people in the United States are entitled to both due process of law and equal protection under the law. The Equal Protection Clause is what's used to guarantee civil rights in this country. But again, initially it was not, the understanding for many years after it was adopted was that it really just protected the rights of freed slaves, but that it did not extend any other basic rights to anyone. And of course, for many years, none of those rights were protected in the southern states after Reconstruction. The state governments essentially began depriving the freed slaves and the descendants of the freed slaves of any rights, and that was the Jim Crow system. So in the 20th century, the Supreme Court began to take the view that the 14th Amendment could be used to guarantee equal protection of the laws in a civil rights context. And they have developed a test for whether something deserves equal right protection or not, based on kind of a classification system. So one of the things you should understand about the law is that all laws classify people into certain kind of areas. So, for example, use the example of driving a speed. The limit for driving, age limit, that you have to be 16 to drive, and of course, there's a rational reason for that. There's an issue of maturity and safety and so forth. The same might apply to the drinking age as well. But what the court has, and so that would generally be considered to be a classification in the law that has a rational basis in facts, that requiring that people be a certain age to drive makes sense, and so that if you classify people that way, that's perfectly acceptable. But the Supreme Court has said that there are some classifications that really don't make any sense. An example would be race, that to classify people based on their racial category or their ethnicity doesn't make sense. So essentially, the court has come up with a three-part test for equal protection, what we call equal protection analysis. And this is a standard that they use whenever they're evaluating any law or public policy that treats people differently. And essentially what they do, what the court has established, and what all courts are supposed to do when evaluating equal protection claims, as they call them, is what is the basis of the different treatment. The first level of analysis is known as strict scrutiny. Strict scrutiny is used for any case that involves a classification that's based on a person's race, ethnicity, or religion. So race, ethnicity, and religion are known as suspect classifications. Now, the term suspect is saying that the courts are automatically suspicious of why a government or a public organization would treat anybody differently because of their race, their religion, or their ethnicity. So anytime a government law, a law passed by a state or the federal government, or a policy enacted by a public institution basically treats somebody differently because of their race, their religion, or ethnicity, that is going to be subject to strict scrutiny by the courts. And what that means is the courts, if they're evaluating a case based on one of those categories, they're going to very closely scrutinize why that organization or that government is creating that distinction between people. And they will assume that there is no good reason for doing so. So the burden of proof is actually on the government or the public entity to defend itself for why it's treating people differently based on race, religion, or ethnicity. And in almost all cases where a public organization has treated somebody differently because of race, religion, or ethnicity, the court is going to tell them they can't do that anymore. Unless there is a necessary and compelling reason why they have to do that. The government or the public organization would have to demonstrate to the court that the only way to achieve a certain objective for that organization or for that government is for them to treat people differently because of one of those categories, and that there's absolutely no other way they could do it. And I truly cannot. I don't believe there are any examples where the court has used strict scrutiny for those categories, and they've allowed the government to continue treating people differently based on that. Now, in the readings, there's a discussion of affirmative action. Now, affirmative action is when race or ethnicity are used in a positive sense, say, for example, for an educational institution when it's admitting students, or an employer when they're deciding whom to hire. Beginning in the 1960s, there was an effort to increase the number of qualified minorities or disadvantaged groups represented in competitive jobs or in jobs that historically had not gone to members of that group, or in educational institutions with competitive admissions. And so race, religion, and ethnicity were used in a positive way in affirmative action policies. But the court actually did rule, the Supreme Court did rule just within the last 20 years, that if an organization is using affirmative action, they will subject that analysis. If they're getting an affirmative action case, they will subject that to strict scrutiny. So over time, the Supreme Court has really dramatically reduced the use of affirmative action by public institutions. It still is allowed to some limited extent, but the court has scaled it back significantly using strict scrutiny. Although originally strict scrutiny was for negative types of classifications, but now they're using it also in cases that involve affirmative action. Now, you'll notice that in the strict scrutiny category, there's one group that's not mentioned that a lot of people think should be there, and that's the issue of gender classifications. Many people would argue that that there's no good reason to treat one gender differently from another gender, women from men, for example. But the Supreme Court has not been willing to put gender into that strict scrutiny category as a suspect classification. They created a middle level of analysis called intermediate scrutiny. Intermediate scrutiny is used only in cases that involve gender, and it basically it's almost suspect, meaning it's kind of another term that is used in the law is exacting scrutiny. Basically, the court says that if they're going to assume there's no reason why women should be treated differently from men under a government program or in a law, unless the government or the organization can explain why it's important to do so. So the standard or the burden of proof on the public institution is somewhat less for gender categories than it would be for race or ethnicity or religion. And a lot of people just wonder why they don't just eliminate the intermediate scrutiny category and just put gender in the strict scrutiny category, but the court has not been willing to do that. They said there could be possibly could be reasons when they would treat one gender differently from another, but it's again, there aren't many cases where that's happened. Some examples of cases where the Supreme Court has basically ruled in favor of or against the government on gender classifications. One would be the case in 1976 when the Supreme Court ruled that a state could not have a separate drinking age for women and men. This was in the state of Indiana, which basically said that women could drink at one age, but men had to wait to another age. So interestingly, that was a case where you could argue that the discrimination was actually against men, but not women. But the idea was that one group was being treated differently from another, and the court said, no, you can't do that. That if you're going to have a drinking age, it needs to be the same for everyone. And so that category was not allowed to remain. Another example of this kind of where the court has ruled against a gender classification was in what was called the VMI case, Virginia Military Institute case in 1996, when the Supreme Court told the Virginia Military Institute, which is a public institution, a public military college in the state of Virginia, that it could not deny admission to women. It was an all-male military academy receiving public taxpayer dollars, and the Supreme Court said if you're a public institution, you have to admit both women and men. And that was a very important distinction, or important affirmation that gender classification was not acceptable. That was a case that was actually decided, or was where the majority opinion was written by Ruth Bader Ginsburg, who recently passed away. So those are all categories that get either strict or intermediate scrutiny. Strict scrutiny for cases that involve race, ethnicity, and religion. Gender cases come under intermediate scrutiny, but both levels of analysis are very closely, the court is going to closely determine why the government's doing this, and the government has to defend itself. Now, the lowest level of analysis is for all other classifications. And again, there are a lot of laws that do classify people differently. The drinking age would be one. Certainly there are a lot of examples of age categories, and there are many others that you could think of. Typically, if it does not involve one of the categories I mentioned earlier, the court uses what's called the rational or reasonable basis test. Now here, the difference is the level of analysis is not as close as it is for strict or intermediate scrutiny, and the burden is not on the government to defend why it's treating people differently, but the burden is on the person challenging that classification. So the drinking age would be an example. If it's not based on somebody's gender, if it's the same for everyone, then if you're under 21 and you wanted to go to court to challenge the 21 drinking age, you're probably going to lose the case, because the court will say that they'll look at why is the government treating people differently. Well, the drinking age is put in place to protect public safety and health, and there's an issue of maturity, a lot of reasons why there's a drinking age. And then they would look at the actual age, that you have to be 21 or over to drink. Now, we know that the federal government incentivizes states to set their drinking ages at 21 so they don't lose highway money. But the courts would basically say that 21 is a rational age. Now, if the drinking age was raised to, say, 40 or 50 or something like that, the courts would say, well, the government has a reasonable, it has a strong reason why it would have a drinking age, but it would not need to set it that high to achieve its purpose. So they would say that age would not be rationally related to the government's purpose. So essentially, what the courts are going to look at in most levels, most classifications, is why is the government doing this, and if there's a rational basis to what they're doing, and the classification makes sense and it's related to the government's interest, the court's going to say it's perfectly fine to treat people differently. So the drinking age is a prime one, and there certainly would be others where the courts would accept that the government does have a rational basis for treating people differently. Now, there have been other issues that have come up in recent years. For example, the issue of sexual orientation and gender identity, and how those categories should be treated under the law. Up until 2015, marriage marriage is an issue that's handled at the state level. There were only a few states prior to 2013. There were only a handful of states where same-sex couples could be married legally at any state. And then in 2013, the Supreme Court issued a decision that said the federal government would recognize same-sex marriage, although it was not requiring that states do that. But by 2015, they took the position that it was a denial of equal protection under the 14th Amendment for a state to say they would allow heterosexual couples to get married, but not gay or lesbian couples, same-sex couples. So the Supreme Court ruled that classification had to be struck down so that same-sex couples could be married in all 50 states plus Washington, D.C. That decision was not based on strict scrutiny or intermediate scrutiny. It was based on the rational and reasonable basis test. So in that instance, they found even using that low level of analysis that there was no rational basis to a state saying that they would restrict marriage rights to opposite sex couples as opposed to allowing also same-sex couples to be married. So sometimes the court, when it uses the lowest level of analysis, will actually side with the people challenging the classification, but it typically doesn't do that. So that's why many people would argue that if you want to protect same-sex rights or the rights of people who are transgender, that you really would need to elevate those categories to suspect categories so they could be subject to strict scrutiny by the courts. But that's not where the court is right now. It's a very conservative Supreme Court, and it's not likely they would be doing that anytime soon. So typically, sexual orientation and gender identity cases will fall under the lowest level of analysis. But again, sometimes using that level of analysis, the court will strike down the classification. So the bottom line is classifications in the law are sometimes allowed. It depends on what the basis of the distinction is. And the courts have three ways of looking at it. Does it involve race, religion, or ethnicity? It's subject to strict scrutiny. It's likely to be struck down. Does it involve gender? Then it's subject to intermediate scrutiny. It's likely to be struck down, but a little bit less likely than it would be if it was one of the suspect categories. And any other category under the law is going to come under rational or reasonable basis. And so that's kind of the level of analysis they've used. There are still many cases involving these kinds of issues. They come through the lower level courts and go up to the Supreme Court, and the Supreme Court is likely in coming years to take additional cases that involve these types of issues. I should also mention, we've been talking about equal protection analysis, but the Supreme Court also uses strict scrutiny when it evaluates issues related to people's civil liberties. So if it's a fundamental right that you have protected by the Bill of Rights or extended to the states through the 14th Amendment, the court will also use strict scrutiny. So anytime your individual rights are in question, the court is going to closely analyze what the restriction that the government has placed on you, and most likely it will say they can't continue that restriction. So I hope that all makes sense. Again, it's important to read through the information in the book, but again, equal protection analysis is a very important aspect of civil rights because so many issues do go to the courts, and so over time the Supreme Court has developed a way of looking at cases involving equal protection based on what is the classification that people are being put into. Again, always keep in mind race, religion, and ethnicity are at the highest level of analysis. Gender is up there as well. Other categories don't get quite the same level of analysis, but the court does look at why people are being treated differently. So again, equal protection doesn't mean that you can never be treated differently. It does mean that if you are being treated differently because of some characteristic, there has to be a good reason why the government or the institution is doing that. And everything we're talking about here generally applies to public entities, public bodies. This college would be an example. We receive taxpayer dollars, so we're subject to civil rights laws. But if it's a private organization, for example, a private country club, they are not always subject to the same civil rights restrictions as public organizations are. Or another example would be a religious group. A religious group has a greater ability to deny service to people than a public organization. But again, you have to look at who they're serving and what's the basis of it. So I know there's a lot of information in there. Always feel free to email me if you have questions, and take care. Thanks.